Good evening, everyone. It is 7:05. It's time for the Zoning Board of Appeals meeting to start. Would everybody please rise for the Pledge of Allegiance? Would our young friends like to lead us?
Do this every day.
Somebody speak up.
The United States of America. You know how it goes.
Republic.
It stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We'll be reporting back to your teachers how that went. All right. First thing we have here, our chairman, Barry Tesseyman, is not able to be here tonight, so we need a motion from members of the board to pick an acting chairperson for tonight. Somebody like to make a motion?
I make a motion that Bruce Simon be the
Acting chair.
acting chairman.
I second that motion, Cary Adwar.
Any discussion of that? Can I discuss it?
No.
All in favor?
Aye.
Any opposed? Thank you. Thank you all. Okay. On the agenda for tonight, notice is hereby given the Zoning Board of Appeals of the Village of Suffern will conduct a public hearing on Thursday, that is tonight, or as soon thereafter possible at 7:10 p.m., Suffern Village Hall, 61 Washington Avenue, by Suffern Auto Service, 20 Wayne Avenue, Suffern, New York, represented by Balsamo, Burns, Cipriani, and Ellsworth at 16 Chestnut Street, also in Suffern, seeking to reverse an administrative interpretation of the building inspector in which he determined the appellant's current use of the parking lot for storage of vehicles for sale is not a permitted use at this site. The premises affected is situated on the north side of Wayne Avenue and is approximately 0 feet from Chestnut Street. The property is listed on the Village of Suffern and Town of Ramapo tax maps as Section 54.27-1-10. Mr. Ellsworth, if you please.
A motion to open the public hearing, did you do that?
No, we did not. Is there a motion to open the public hearing?
I motion.
Second?
All in favor?
Aye.
Aye.
So, Mr. Simon, you'll have me present before you ask the public to speak?
Yes.
Thank you. Board members, Richard Ellsworth for the appellant, Suffern Auto Service, hereby Pincus Neiman, my client. If I can address certain procedural issues at first, I would appreciate it. And this is an interpretation of a building inspector determination found under 266-54E of your code. I believe a GML was completed appropriately, and there was no objections and recommendations that had to be sent back to this board for an interpretation. Public notice was properly given back when we first applied, and I don't know how this board is going to address seeker, but I would take the position that it's a type 2 and no action need to be taken. So just procedurally, I wanted to address those issues first.
Just procedurally, it's not subject to the New York State General Municipal Law or GML, Section 239L, et cetera, because it's an application for an interpretation. So it's not subject to the GML requirements. And similarly, under the State Environmental Quality Review Act, it is type 2. It is exempt, so I agree with Mr. Ellsworth. It's exempt from environmental review as a type 2 action under SECR.
The GML was sent out, though, by the village.
It's often done as a matter of course. You know, doesn't do any harm to send it out, but legally it's not required.
So initially, with respect to an interpretation, and I am not before this board very often, although I am before other similar boards, interpretations by zoning boards are not an everyday occurrence, and we're normally looking at something like a variance, whether it be area or use. So a code interpretation is a little different. I would just like to present to this board that the code and the interpretation under 266-55 of the Village Code requires a record on appeal from the agency that we're appealing from. So I don't know what this board has been given by the building department and what the record on appeal is that this board is reviewing. And I would ask if the board has a record on appeal for this matter.
It definitely does, and I've been involved in many emails, and I thought I saw a few at least that where you were sent correspondence and records, and most recently, I think yesterday, you were sent some additional photographs and information that was to be made, that is being made part of the record, but the record is a living thing in the sense that it's constantly being updated. Right now, your testimony is being made part of the record. So there isn't a record that was written in concrete sometime in the past and we can hand it to you now or yesterday or a week or two ago. In fact, there's going to be testimony perhaps from one of your clients, there might be testimony from a neighbor, there might be correspondence or reports or letters or other documents that we received tonight during the public hearing, or if this public hearing is continued, that would be made part of the record. So to answer your question, Mr. Ellsworth, the record, there is documents and other papers that are already part of the record, but that record may very well be supplemented through the continuation of this public hearing.
Right, so I appreciate that, Counsel. However, your code is clear that there is a record that is used by the underlying agency and that it is transmitted to this board for its determination on the interpretation. It's the record that Mr. Cyril Gagin created when he interpreted the code that you have to further interpret whether it was proper. So I disagree that it's a living, breathing record. It lives and breathes for a further review by another agency, but not for your review here. You have a record that you need to review.
Rich, there is a record right now at this moment that exists, and you've, through a Freedom of Information Law request, which you didn't have to submit to get a copy of the record, by the way, you could just walk in and say, I'd like the record for this application, for this appeal.
Dennis, that's my point.
So are you saying you have not received any correspondence and nothing that is related to this application? You have not received any paperwork?
The paperwork that I've received is minimal and after the decision. Most of it is created after the decision. In fact, an email I received today from the village clerk is a printout of a website from today. That can't be before this board if was not before Mr. Gagin, because you're interpreting Mr. Gagin's determination, and he did not have that to interpret. So I'm making a record now for further review, obviously, and we obviously have a difference, but your code is very clear that a record has to be submitted to you by the underlying agency for your review. And it has to be the record that the underlying agency used to make its determination.
Okay.
And if you don't have it, you don't have it. I appreciate it.
So noted. So
Okay.
noted. Thank you.
And your reference to the FOIL request is very telling as well, because I requested all those records that Mr. Gagin used to interpret this code, and the file was void of anything. And then I received documents afterwards that should have been in that file, that should have been foilable, that I should have been able to look at.
Okay, if you think that entitles you to some legal remedy, by all means, you may pursue that.
I haven't stated that nor implied it.
Your comments and objections are noted for the record.
Okay. So with respect to the documents that were sent to me today, I do want to make that record that they are inadmissible for the purposes of this this hearing. We'll certainly address them if this board thinks otherwise.
So noted, but I legally disagree. Board, you may consider the correspondence received yesterday. I believe it contained photographs that were submitted by ad hoc member Stephen Marks, and any other information that you received related to this application. In my legal opinion, you may consider and review. Again, Mr. Ellsworth will object to that, and he's noted that for the record.
That's fine. With respect to the submissions, and the submissions were not in its entirety, and I believe the submissions were meant, although I can't interpret whoever, or I cannot determine the decision made by the person who printed them, but I take it they were submitted to this board to show that the company Deals on Wheels is selling out of a Suffern address, but the front page of the website that was not circulated shows the address as New Jersey. So another reason why the record should be clear at the beginning and not supplemented for these purposes. However, I do have 6 submissions showing the front page of the website and the partial submissions by the board member showing that the address is 65 Ramapo Valley Road, Mahwah, New Jersey. And if the board is going to consider the other pictures, then it should be considering the entire website.
By all means, they are, and they will consider this document, correspondence. For the record, Mr. Ellsworth has submitted some documentation to be made part of the record, to be considered by the Zoning Board of Appeals in its deliberations and review of the application, and it's my legal opinion that those are acceptable to be made part of the record. What weight you give them is up to the board, as with any document or information that's made part of the record, or testimony.
And my submission of them is not an indication of waiving my objection that I just placed on the record. It is just if in fact you are going to overrule my objection, then you should see the entire record.
Thank you. Thank you, I'll keep it. We got it.
The board has, I'm sure, my narrative of May 20th and the history of the property I don't think is in question. It has been used for the last 35 years as auto repair, parking, storage of vehicles. Whatever the definition of storage, obviously that is your position, that is your obligation here to interpret or decide. Mr. Donato, the prior owner, had both lots, one on the south side of Route 202, one on the north side of Route 202. The north side was empty for parking and storage. My client purchased the property several years ago and found out that there was a violation on the empty lot, one that was never addressed against Mr. Donato, never served on Mr. Donato, but once my client purchased the property, he received a violation. He complied with the violation, went to the planning board, obtained a site plan approval for the parking lot, beautified the parking lot, fixed the wall along Route 202, and complied with all the requirements of the village. The 2 lots in question are permitted in the zone. The lot on the south side contains a garage where auto repair is conducted. Under Article 6 of the code, a special use permit was granted when Mr. Donato, the father, opened the business. An accessory use for the zone is also permitted as outdoor storage of vehicles. The outdoor storage of vehicles is on the lot across the street on the north side, and the storage is incidental to the business, which would be a requirement for a accessory use. The building inspector, after the planning board referred the matter to him, when it was determined that there were additional cars parked on the lot, or alleged that there were additional cars parked on the lot, my client went back to the planning board to amend his site plan to change the configuration of the lot to allow those additional cars. Planning board referred it to the building inspector, which resulted in our presence here. The building inspector discussed and investigated this matter with my client, made many requests for information, again, none of which was in the file of the building inspector, and sought assistance from counsel. My client will testify shortly with respect to what he discovered from the building inspector's investigation. Despite the building inspector's intimation that the lot was used properly, the interpretation came down contrary to that, stating that the cars that were stored there were stored unlawfully. We submit that the use by the owner is lawful in the zone. It is an automobile shop across the street with the adjacent lot, and it complies with the code. The code is clear that outdoor storage of vehicles are permitted. The owners the owner has a separate business in New Jersey on Ramapo Valley Road. He does sell automobiles. He sells automobiles from that location, not from the Suffern location. It's not a secret that he thought he could sell them from the Suffern location based upon his interpretation of the code, but when he determined and when he was told he could not, he ceased that almost over a year ago. The automobile shop, the lot across the street stores the cars for use by the automobile shop to repair them. The owner's car business is called Deals on Wheels. It is in a New Jersey location. They sell used cars. These cars require servicing, and they require to be tested. He uses his automobile shop to perform the servicing and the testing. They are not sold until they are roadworthy and ready to be driven. They have to be tested once again before they are passed to a new owner. After the first set of testing, they remain on the lot. Somebody buys the car in New Jersey, and now the Deals on Wheels takes it away. Prior to them taking it away, they do the final test, and they do the inspection for New York State, I believe. After the cars are inspected, they're gone. The whole purpose of the lot is to service and repair cars. The cars that are on the lot are serviced and repaired. They are not stored for sale. They are kept there for future repair because it makes sense for his business, and it makes sense for his second business to do just that. There's no violation of the code if the cars are being serviced or will be serviced in the future. I would like at this time my client to take the podium and make a statement, and then I'll make a summary, and then we can, I guess, open the public hearing.
Yes, we do. Sir, would you please raise your right hand? Do you promise to tell the truth, the whole truth, and nothing but the truth?
I promise to say the truth and nothing about the truth. I'll start off.
I'm sorry, can we have your name, please?
I'll start off to introduce myself. My name is Tesseyman.
You have to speak up. Can you speak up?
Maybe move the microphone closer to you.
My name is Tesseyman. I'm the owner of Suffern Sales and Service. I bought this property 3.5 years ago from Mr. Denaros. We've been dedicated to provide top-notch service for our customers, to inspect the cars, take care of the cars, ensure every vehicle is in the best and safest condition possible. After purchasing the property, I found out that the parking lot at 20 Wayne Avenue was never approved, so I had to submit a site plan that I've been using this as a sublot for the mechanic shop at 23 Wayne Avenue. On May 15 of 22, I received a complaint that used cars are being sold on the lot through a different company. Later on, the code enforcement complained that I have 50 cars instead of the original submission of 35 spots. On November 7, 23, we submitted a new parking layout with 50 spots on the planning board. They directed us to the building department regarding the illegitimate of selling cars at the property. I had a discussion with many discussions with our former building inspector, Mr. Cyril. I learned from our conversations that our operations comply with all necessary regulations. He even mentioned at once that he doesn't understand why I'm being given such a hard time. Suffern Sales does not sell any vehicles to customers on that property. No customers come to that property to buy a car. Neither any other company doesn't sell any cars off that property of 23 Wayne Avenue. The cars that you can see there is actually from our main customer service, that's Suffern Sales and Service. That the customer obviously is Deals on Wheels, that I own that company as well. They bring the cars to Suffern Service to repair them before they can sell them. Just to explain how the operation works. As soon as they buy a car, they bring us the car. The first thing is they want the car should look decent and look normal. So any body work or any main things that's wrong with the car will be fixed. At a later time, when they are ready to sell them, they want it should go through a full diagnostic, and at that point being rechecked, oil change, New York safety inspection, whatever is needed, brakes, rotors, or whatever it is for delivery to retail customer. Every single car is at least twice or even more than that fixed at the shop at a longer period of time, and this is what was given to you guys besides the cover sheet of the website from Deals on Wheels that shows our address correctly, is that there's bills. Every single car is billed to Deals on Wheels from Suffern Sales and Service, and every single car has at least 2 bills with different dates. And this is just printed out from my, it's called Shop Monkey, that I'm using to bill the customers. And every car has at least twice bills. I just took a random, and this is how every car is done. It's important that car stays at that lot throughout the fixing process so we can make sure everything is done right. Also, it allows us to work according to our own schedule. We shouldn't have to call it back. We have it there, so whenever we have time, we can use it as fillers to take care of the shop that the mechanics should always be scheduled accordingly. It also saves Deals on Wheels, of course, from having transferring back and forth for every single repair that's needed. And like I said, the final inspection can only be done once the vehicle is confirmed to be sold. This customer Deals on Wheels is crucial for our shop's survival and allows us to stay in business and to serve our community and provide jobs for our local mechanics. I've noticed a difference in the way I'm respected compared to Mr. Denaro when he had his shop. It's hard for me to understand when he owned the shop, with all due respect to Mr. Denaro's, the place was run down. I printed a picture how the place used to look and how it looks now from both the shop and the parking lot. This way you can see how the shop used to look and how it looks now. And this you can see the parking lot, how it looked before with all these stones and how it looks today's days.
Sorry, is it Mr. Neiman or Nyman? Neiman or Nyman? Sorry.
Whatever you want.
Would you like to make those part of the record? Otherwise, it's going to be hard.
Okay, yeah, we
The
can do
board
that.
to really consider it.
Yeah, sure.
All right, so let the record reflect that 2 poster-size color photographs of a before and after June 2021. Two separate sheets, poster-size sheets, depicting different photos, images, are made part of the record. Thank you.
Thank you. I don't understand why I should be treated differently when all we're trying to do is to run a respectful business and make a positive contribution to our community. I'm looking forward for your understanding and support to this matter so we can continue serving our customers, our local community with a professional and honest approach and making sure our local cars are safe on the road. Thank you.
Oh, just correction, there are 3 sheets. Are there 3 altogether, 3 poster size, Mr. Neiman? It looks like we have 3 here, right? Are they duplicates? No, they look different. Is it 2 or 3?
I think it's 2.
Wait, so, sorry.
Thick, they're just very thick.
So it is 2. It's only 2. Thank you. Sorry about that. Sorry, Melissa.
I'm gonna yield until after the public hearing portion, if that's all right.
Fair enough. think at this point it would be appropriate to invite the public to speak. If anybody would like to speak, please come up to the microphone, state your name and address, and you will be heard. Seeing as no one is rising,
Note for the record, no response.
Board members, I don't want to repeat what my client said, or I do want to intimate that the actions toward my client compared to the prior owner could be determined to be arbitrary, capricious. They could be determined to be contrary to lawful statute. The statute that we're dealing with is very clear. It says storage in the lot. There are no other lots in that CB zone that are similar to Mr. Donato's. The code applies to that lot almost entirely. And he's storing cars in that lot for the purposes of repairing them, which is a lawful purpose under your code. We take the position that the building inspector's interpretation was incorrect and should be overturned by this fine board. And we thank you for your time.
okay. I'd like,
Questions for my client?
there may be. I'm going to ask the board members if they would like to weigh in.
Yes.
Start with, on the far end, Mr. Zavoski.
Yeah, I have a question on the mechanics of the operation of the business. If it's being just for storage, as far as the licensing goes, how do you get the vehicle to Jersey? Do you take it in a tow truck or, a flatbed truck? Or do you drive it there for delivery for the person who wants to purchase it?
Mostly driven,
Mostly driven.
99%.
Okay, so the customers never come over to the New York line to engage in any kind of transaction with the vehicle?
That's correct.
All right, thank you.
It's approximately 1.2 miles from 65 Rampo Valley Road to 23 Wayne Avenue, I believe. And I was wondering, is there a lot on 65 Rampo Valley Road where the cars for sale can be stored?
It's a big lot, it's a big parking lot. It's not separated as a showroom lot, but it's a big lot and we always have cars at 65 Rampo Valley Road as well.
Thank you.
Ms. Wilson?
I have a couple of comments. I mean, in Mr. Ellsworth's narrative, he said that the cars are an accessory to the use. Well, the use at Suffern Auto Service is auto service. In my opinion, in an auto service, the car should be owned by a third party. It should come there for engine work, body work, whatever, and then when that is completed, return to the owner. But in this case, there is no owner, and then once you've completed that work, you're now storing the car for sale, which is the indicative thing that is against the code.
Well, there is a third-party owner, that's Deals on Wheels. The fact that there are two entities, two corporations, that one person may be affiliated with both, doesn't change the fact that it is a third party seeking car repair service, car servicing, car inspections, and it is benefiting two different businesses, one the car repair and one the car sales. And he has been very clear on not to sell those cars there, and the fact that the cars remain there are not remaining specifically for sale there. They're remaining there for further service for when somebody at a third-party location wants to buy them, so they can then finally service and given to back the Deals on Wheels to transfer to the owner. So it's not a matter of splitting hairs, I understand, but it just can't be a business owner should not have to rely on an individual who owns a car in their driveway to keep him in business if he can find a proper way to find other business and still stay within the code. It's not a matter of, he's allowed to store per your code, and he's allowed to store if it's incidental to the business that the accessory parking is there for. So I respect your position, but I take exception to it because I believe we fall within the parameters of the code.
I think we're arguing about storing and parking. Parking, the car would be brought there to be parked while it was waiting for parts, while it was waiting to go into the paint booth, what have you. But this car is unregistered, correct?
I'm sorry?
The car is not registered.
It's not registered to a new owner. The owner of the car is Deals on Wheels. So they would have to transfer it to a new owner.
Well, if it was registered, it would have plates on it,
Okay, go ahead.
correct?
Yeah, it's not registered. It doesn't
It's
say
not registered,
anywhere it's
exactly.
registered.
So
We have a
owner-
customer with unregistered cars that service their vehicles at the shop.
It's an unregistered car,
Correct.
and it's being stored, not parked.
It's being serviced at the shop.
Okay. Your words, my words.
Well, keep in mind, storage and parking are permitted under the code, as long as it is incidental to the primary use. And the primary use, as we indicated, is auto service shop, or auto repair shop.
But you're stretching the truth by saying that it's being serviced, and then we're going to wait 4 months, 6 months until someone wants to buy the car, and then we need to take it back into the shop because maybe we didn't service it correctly the first time. We're going to take it back in the shop and make sure it's ready, and then it's going to go to this person.
Well, I don't know if we're stretching the truth. We're defining the code as we see it, and we believe the building inspector defined it improperly or interpreted it improperly. That's why we're here. Again, stretching truth seems to indicate that we don't believe what we're saying here. We do believe what
Oh,
we're
no,
saying.
you believe what you're saying, and I understand what you're saying, but I feel that you're interpreting the storing differently than I am.
Well, again, then there's nothing specifically in the code that defines storage
That's
of vehicles. It is specific to that zone, and it has been interpreted in the past, not specifically for my client, that it should be incidental to the primary use. And as we are presenting it to you, it is incidental to the primary use.
I have a question. If the car is not registered and doesn't have any plates, how can you drive it to Jersey?
Temporary.
We have dealer plates for that.
Dealer plates.
Oh, dealer plates?
Yes. And back to your question, Lisa. There is certain services that cannot be done beforehand. For example, battery to change. Batteries die just by sitting. New York safety inspection has to be done within a couple of days of the sale. So there are certain things that cannot be done beforehand. So this is the process, and this is how it works.
I just have a couple of follow-up questions, and I thank you for being here, Mr. Pincus. So where is Deals on Wheels dealer license given to? Where is it for? The dealer's license for Deals on Wheels?
Deals on Wheels is a brokerage.
Is a brokerage, and it's a brokerage, so it is not a dealership.
It's a broker license.
Okay, so I'm just confirming it's not a dealership.
Correct.
Okay. In viewing the website, I did come across pictures of the cars that have been taken, and can we agree that this is taken at the lot in question? Right? Okay. So what is the purpose of taking these pictures on this lot?
The car is physically there. This is where we take the pictures from. The second that we try to move, in order to make money, the main game is how fast you can move cars. So the second it looks decent from the outside, we will take the pictures and put it on the website.
And
so
what-
obviously it's at that point when it comes out from the body shop.
Okay, but again, what is the purpose of the car being on the website and the picture being taken there?
Most of our customers don't even see the car before they buy it.
Before they buy it,
Before
right?
they buy it.
So,
The
Like-
only thing, the maximum they want to see is some pictures. That's all they want to see. If they do want to see the cars,
so
we will never tell them to come to 23 Wayne. They'll come to 65 Rampart Valley Road where we'll show them the car.
okay, because I'm just concerned when I'm looking at some of this documents here on the website where it does specifically list to call for address, Suffern, New York, stop by our lot. Which lot are they referring to?
It's not referring to any lot. My lawyer told me about it today, and I already changed it, what matters. But it said clearly call us, and the reason is because it's not always at Ramapo Valley Road, the car, and we don't like customers to just see a car and walk in thinking that they're coming to see the car, and therefore, we just had originally Suffern. I never saw that it's now deleted. I thought it's taken off. But the main thing is call us for, I live in Muncie, the office is in Mawa. We just need the area to show people that here is where you'll find us.
So help me understand why the Ramapo Valley Road address isn't listed there then.
So it is listed when you see on the main page of the website. That's what we submitted.
So, however, it's listed as...
When you look in the used cars, I don't want people to think that they can just come and see the cars, because it's not there, ready to see at all times.
Okay. Thank you for that clarification. Another piece of question I have is, it says here for trade-ins, that we want your trade-ins for your cars, right? And in there it says, hold on one second, pull up my notes, I'm sorry. I have like a whole little binder of stuff. We want your vehicle, get the best value for the trade-in. Can you go over what the trade-in process is for your customers?
If somebody will call in for a trade-in, it will not be done at 20 Wayne Avenue.
Okay, but can you explain the process?
How it works?
Yes.
I'll tell you how it works by us mainly. It's an issue, but this is how it works currently. If somebody wants to trade in a car, it goes by WhatsApp pictures. We tell them you have to describe every scratch. If there will be any scratches at time that we get the car and we'll see that it's different than you show us, then we'll have an issue. It's an issue because it's very hard to go after a customer and say, hey, you didn't disclose this, you didn't disclose that, or you should have looked better in the pictures, you can see it, you can't see it. So it's a tough situation, but we trust our customers. We deal mainly with our unique, tight community, and most trade-ins goes by WhatsApp pictures. We evaluate the car, we pull to see how much they owe for the bank, and we have a conversation. Hey, you have equity or you have a negative equity.
And when they return the car in, where is it turned in?
It's
A trade-in?
yeah, it's always at 65 Ramapo Valley Road, or at the customer's lot. We deliver cars to the customers, so it's or the customer's house. We give him the new car, and we pick up the trade-in.
Okay.
99.9% trade-ins is only if customers buy cars from us.
Okay, and so just going back to the lot, situation, when you had, do you ever invite customers to come to the lot to look at cars?
You're talking about 20 Wayne Avenue?
Correct.
Never.
Never. Okay. So you never invite customers to come over to look at the lot. Okay.
Mr. Marks, that is from the current process forward. There was a time when there was an allegation, and we advised the client several years ago that was not permitted. That was in my presentation.
Okay.
So you understand that?
Thank you. I appreciate that. Thank you for that.
Mr. Marks, anything else?
Nothing by me.
Okay. I have a little bit, if you don't mind.
Bruce, you need my client?
Nope.
Okay.
Actually, Mr. Ellsworth, I think you may be able to answer these questions. The Code of Suffern is very clear about not allowing vehicles in the village that do not have registrations and license plates on them. Would you agree to that?
Bruce, I respectfully am not testifying today, so you're asking me questions like that. I don't have the code in front of me.
Okay.
Unfortunately, I plan to bring it. It's probably sitting on my desk. But with respect to your interpretation of the code, I'll respect that, but I can't be cross-examined by the board.
Okay. Didn't mean to cross-examine you.
No, I'm not, and I'm not being disrespectful.
Not at all.
I know you. I'm not. But
Not at all. Mr. Nyman, actually, I do have a question or two for you, if you wouldn't mind coming back to the microphone. Are New York inspections valid in New Jersey?
It goes where the customer lives, it doesn't go where you sell it from.
Okay.
Our main customer base is Muncie, New York, or Brooklyn.
Okay, but if you're selling a vehicle in New Jersey, as your address is in Mahwah, wouldn't you need to have a New Jersey inspection?
No. It goes by customer where the customer lives.
Okay. Another question. It was stated earlier that the use of the lot is an accessory use for Suffern service. Except Mr. Nyman, and I believe Mr. Ellsworth as well, has said that the use of the lot is for the storage of the cars for Deals on Wheels.
I did not make that statement, but if that's what you heard, I'm not going to change what you heard. I can tell you what the use of the lot is for. The use of the lot is for parking and storage for Suffern Auto Care. Car service. I still call it Donato, so I apologize. But the fact that they have a client that brings cars there from Deals on Wheels and parks them there for service is what our argument is here. Storing for Deals on Wheels is not their intent. Repairing and servicing for Deals on Wheels, a client of theirs is.
Just to follow up with that, and I realize the intent is an important piece of this, right? Because like, what are you intending to do with these cars, right? And the intent is for repairs, but you're also taking photos of the vehicles on the lot. You're also advertising those photos of the vehicles on the same lot with a price. Is that not people being able to shop or sell on that lot?
I don't think anybody will notice by the pictures where the address is. It doesn't say the address, they won't get the address, it's just a background picture.
Right.
Some pictures are taken at 65 Amber Valley Road as well, if the body looks okay.
Okay, but the one thing I'm hearing is that your intent is not to store, but to repair, clean, and all those kinds of things. But here is just a photo of the vehicles being taken picture of on that lot for Deals on Wheels, with a bunch of other cars there too. And, we can figure, whose cars those are. Might be different people. But what I'm hearing is that the intent is different from what you're actually doing to what it sounds like is you're making the sales or advertising the sales from that property. That's what I'm seeing just on these pictures alone. I know you're telling me that, that's not the purpose, because you just said the purpose was to repair, fix, clean, whatever that is, but there's another purpose going on in that lot, correct?
I disagree.
Okay.
You may want to look at the other photos on the website, that most of which do not depict any background of a Suffern parking lot.
It does. There is a sign on one of them.
But there are the majority, I believe, are depicted in New Jersey. So the 3 or 4 that you have, I acknowledge that is a Suffern lot. But it's also pictures taken by Deals on Wheels and not Suffern Auto Service.
But again, the intent of what I heard is for repair and cleaning, not for storing for their vehicles and doing other things.
Well, my client, Suffern Auto Service, is repairing and servicing.
But this is not repairing and servicing.
And that's pictures for Deals on Wheels, a separate entity.
That's on the lot that's meant for repair and servicing.
And Deals on Wheels has every right to go on the lot and take a picture while the car's sitting there.
Thank you.
When you browse through all the cars, you can even see sold cars. There's many cars that was taking the pictures at the 65 Amber Valley Road, and there's many cars that was taken at the car wash, Joey's Car Wash.
Gotcha. Thank you.
Wherever it's ready, it's nice weather, they'll take pictures.
Yeah. I understand. Thank you.
Can you comment on the volume of vehicles going out of the lot? Is there a lot of volume going on a monthly basis, or is it like sporadic, or?
It's hard to answer that, but I would say an average 10 cars, most, less than 10.
Thank you.
Do any of the board members have any other questions? Okay.
So the next procedural question for the board is there any testimony that you can think of now that you'd like to hear from any person on earth within reason? Any documents you'd like to get a hold of that you can imagine that you heard a mention of tonight that you don't have as part of your record? Anything at all that you still require to review, to see, to look at, including a site visit? I don't know if any of you have actually gone to the site. That's something.
Yes, I did. I did go to the site at one time, and I believe I met with the owner there. It was very nice.
If not, if there is nothing further that you can imagine that you'd like to see, hear, or touch, or feel, then you should feel comfortable in closing the public hearing. I always suggest that that's something that you should be very cautious about, because invariably after you close the public hearing, you'll start to discuss the application amongst yourselves, and questions arise, usually for the applicant. But if you've closed the public hearing, you cannot hear from the applicant. The only person you can hear from is your legal counsel. That's it.
I don't know if any other board member would like to go to the site. That's up to them.
I want to add, in the part of unregistered vehicles, we have, from different clients, Suffern Police Department, sometimes they will call us on if somebody's driving without or anything, they'll take away the plates and they'll give us to tow the car without any plates, and it will be on our property for a long time unregistered.
Thank you for that.
And for example, there might be further information from Mr. Nyman that you'd like to see, based upon the testimony or the testimony that Mr. Ellsworth offered you this evening. Maybe there's some documentation that you'd like to get from either Mr. Nyman or Mr. Ellsworth, if you would have it.
Is the operation of the business 7 days a week, 5 days a week? And is it in sync with the, Jersey office? And how many people are in the Jersey office?
We don't work on Saturday and we don't work on Sunday. Fridays, half days now in the winter.
Okay. Is both offices open on those, are they both in operation at the same time? Your Jersey location and the New York location?
Yes, we are open just because this is, we don't work on Saturday because we're Jewish.
It should be clear that there are many other clientele at this location that bring their vehicles in, whether it be another car dealer, which I don't believe there are, or an individual. So it's there are people coming and going at all times here, not just the cars that obviously you have an interest in. And if you do want a further submission showing Deals on Wheels on a business heading in Mawa and pictures of it, but that should be all part of the building department file, showing the actual location, showing the pictures inside the office, and showing the room or the suite number where they operate out of. I'll submit that to you as well.
Thank you. Just for the record, how many sheets, I can count them up quick unless you know offhand, Rich, how many total sheets are there?
I actually didn't realize that there were so many. I think they did 6.
Oh, wait, are these several, oh, okay.
6.
Rich, sorry.
4 pieces,
Is this the entirety of what you just submitted?
There's 3, I think.
4 sheets,
Okay, and those are just duplicates?
yes.
Gotcha. Okay, so for the record, the applicant's attorney, Richard
We got
Ellsworth,
these already.
submitted.
We saw them.
We just didn't see this.
No, let's
didn't see
it
this
doesn't hurt.
first.
4 sheets. So for the record, it may already be part of the record, but just to make sure, 4 sheets, 8.5 by 11, of what appear to be photographs, I think, all photographs, black and white photographs, 4 8.5 by 11 sheets of photographs will be made part of the record to the board's consideration.
Mr. Chairman, or Mr. Acting Chairman, if you find it
Please, emphasis
necessary
on
to
acting.
continue and keep the public hearing open, I have no objection to that. If you are looking to make a determination tonight, obviously, but I have no objection if you, Mr. Zavoski indicated going to the site. If you want to keep the public hearing open and bring us back, that's fine.
Thank you for that.
So, what, I don't want to repeat it again, I'm sure you've heard it enough, is, do you feel you have all the documents that you could possibly envision that would be relevant to this application that you would need to make a reasoned decision that's not arbitrary or capricious? And have you heard all the testimony and gotten the answers that you'd like to get? Again, in order for you to make a reasoned determination, decision that's not arbitrary or capricious, do you have what you need?
I have what I need.
I have what I need.
I'm sorry?
We have what we need.
Have what you need?
I have what I need.
Okay. So then you certainly may close the public hearing. But again, you can't ask Mr. Ellsworth anything, or Mr. Nyman, or anyone here, except me. You can ask legal questions. That's it.
Okay. Before a motion is made about whether to close the meeting or not, do any of the members feel we should retire briefly for legal advice from counsel?
I do.
I do.
I do as well.
Okay, so the New York State law and the New York State Open Meetings law allows you to go into a private attorney-client confidential discussion. It is not an executive session. It's often mislabeled as an executive session. It's not. It's just simply an attorney-client confidential discussion, just like any client has a right to discuss, ask legal questions of their attorney, and to hear his or her advice or answers in confidence, in private. You have that right. And do you have legal questions for me? I think you indicated you do. And you'd like to hear my answers in private in a confidential attorney-client privilege discussion?
Correct.
All right, so is there a side room we could go to?
Yes.
There is. Do we need to make a motion to do so?
I don't think so. It's not an executive session. It's,
Okay. Thank you all for your patience. We are back. The time is 8:18. After discussing with council processes and procedures for moving forward, I think the first thing we're going to do is ask for a motion to close the public hearing. Is there a motion?
I make a motion to close the public hearing.
Ms. Wilson makes a motion. Is there a second?
Second, Cary Adwar.
Mr. Adwar makes the second. All in favor?
Aye.
Aye. Any opposed? There you go. Now, I am going to take a quick survey of the members, non-binding, how they feel right now about where we are in this process. We'll start with our newest member, Mr. Marks.
Yep. I'm feeling currently right now that the report given by Cyril Gagan, the building inspector, on April 22nd, 2024, and the testimony that was given today regarding this, I'm feeling that I will affirm his decision.
Thank you. Ms. Wilson?
My opinion, after reading Inspector Gagan's letter of 4/22/24, I agree with his interpretation of the storage of cars.
Mr. Zavoski?
Yes, after reading the letter from Cyril Gagan in April 22nd, 2024, I more or less concur with his finding.
Mr. Adwar?
After reading Cyril's April 22nd, 2024 memo and hearing from Mr. Ellsworth, his client, I agree with the building inspector's interpretation.
And I will agree with my fellow board members. Mr. Michaels, where does that leave us?
well, again, it's as you asked, acting chairperson, that's an informal poll. It's non-binding. You can always change your mind when you actually vote. Did you want to vote tonight, or did you want to ask your legal counsel or village clerk to draft a prospective, tentative, proposed resolution reflecting what you've generally seemed to have a consensus on tonight for your consideration at the next meeting, which is a draft only, which you can, of course, amend, you can modify, you can reject it, but it would be something that you would need to authorize either your village clerk or your legal counsel to draft for your consideration again at the next meeting to make sure that it reflects what you, at least the majority of you feel. Is that something you would like to do?
I think I can speak for everyone to say, yes, that is something we would like. The draft to be discussed more at the next meeting, not have a vote this evening.
Agreed?
Is that a,
Yes.
I don't think we need to have a vote on that. Well, you know what, for the record, let's, is that a motion by the acting chairman? A motion to ask, I'm assuming it's going to be legal counsel you'll ask to draft that?
Correct.
Okay, to have legal counsel draft a tentative draft proposed non-binding resolution reflecting what appears to be unanimous feelings expressed tonight about affirming Building Inspector Cyril Gagan's April 22, 2024 determination. Is there a motion by acting chairman to that effect? Is there a second?
Second.
And
Second?
I believe Mr. Zavoski had the second.
Member Zavoski already
Okay.
seconded, so is that unanimous?
All in favor?
Aye.
All right, so I will draft a tentative proposed non-binding resolution for you guys to consider at the next meeting, which will be January 9th.
January 9th.
January 9th.
And the public hearing is closed, so that's solely for purposes of deliberations only. So for agenda purposes, Melissa, you put this on the agenda as other business, whatever makes you comfortable, and make it clear that the public hearing has been closed, and it's for board deliberations only. Public hearing has been closed and for board deliberations only.
Members of the board, thank you for your time. Dennis, thank you. Melissa,
Thank you.
If for some reason it is calendared to a later date, I just want to come to make sure the vote occurs and when the resolution will be filed. So
Sure.
Thank you.
Of course. Thanks, Rich. Happy holiday. We should announce the continuation of Cypress Road. You want me to do that?
Please.
For the record, 21 Cypress Road, application will be continued. The public hearing will be held open and be reviewed at the next meeting, I assume? Next meeting?
January 9th.
Yes.
Of January 9, 2025, 7 o'clock PM here in Village Hall.
Okay, thank you, sir.
Minutes.
Next, yes, we have to adopt the minutes of the October 17th, 2024 ZBA meeting. I would just say for the record, Mr. Mark, since you were not a member, you will not be voting on
Didn't
this.
plan on it.
Is there a motion to adopt said minutes?
Motion?
Ms. Wilson.
Second, Cary Adwar.
Second, Mr. Adwar. All in favor?
Aye.
Aye. Is there any other?
Abstain.
Thank you.
Just for the record.
For the record. Is there any other information, anything else we need to discuss this evening?
Yeah, we need to, when we adjourn, propose the meeting for January 9th, and if you'd like, February 20th.
Okay.
Oh, February 20th?
So although we have announced January 9th, we do actually have to have a vote about that.
Yes.
Is everybody in favor of January 9th?
Yes.
Yes.
That's okay? No? Totally fine. And while we're here, how about February 20th?
Yes.
Unless you'd like to skip February because it's cold.
I don't know if that's a valid.
Well, I should be here. For the record, I am available in case Rob should have some issue on February 20th.
Rob's got plenty of it.
Rob, it should be Rob.
Yes.
You should probably never see me again, although I will miss you all.
Never, ever. February 20th does work for me.
Yes?
Yes.
All right, so we have adopted January 9th and February 20th.
Okay, and who moved it?
But you will see me on January.
I believe that was Ms. Wilson, seconded by Mr. Adwar.
No, they did
Oh, okay.
minutes. So can you have somebody move it?
Would somebody move the adoption of those two meetings?
I move to adopt, what was it?
January 9th and February
To
20th.
adopt our meetings for January 9th and February 20th at 7 PM, Village Hall for ZBA.
Okay, is there a second?
Second.
Mr. Zavoski seconds, all in favor?
Aye.
Seeing as there is nothing else, thank you all. We bring the meeting to a close at 8:25. Happy holidays.
Yeah, happy holidays.